Denton County Appraisal District is lawless, ignoring a multitude of laws, then covering up their actions using taxpayers' money is a direct correlation to Ponzi schemes. Theft at any level and any value is nondiscriminatory. Theft of your money and my money is illegal and unforgivable. Theft of billions is criminal. DCAD has engaged in a criminal conspiracy to defraud real estate taxpayers. The evidence of what was done, how, and by whom is irrefutable. If you own property in Texas, this video may save you thousands, if not tens of thousands of dollars. In this short video, what you are about to see is a series of graphics containing evidence of how DCAD, Denton County Central Appraisal District, is committing fraud on a mass scale against the taxpayers of Denton County. The aerials and photos throughout this video are being presented to show you all types of real estate that have a high probability of being impacted by the fraud perpetrated by Denton Central Appraisal District with regard to the annual initial notice of appraised value. The press has written over 80 articles about Denton Central Appraisal District since December 2020. Many from the past year can be seen at www.mockingbirdproperties.com/DCAD. My company has been enormously affected by this fraud, and as a result, we have spent thousands of hours in research in order to quantify and prove how the fraud is committed. Although we are preparing for upcoming litigation, we are opening our research and files to the real estate taxpayers of Texas, all of which is available at www.mockingbirdproperties.com/DCAD. We'd like to provide an overview of the real estate appraisal. Let's start with the Uniform Standards of Professional Appraisal Practice, or USPAP. USPAP is the recognized ethical and performance standards for the appraisal profession, from which both international and national appraisals are derived. Its purpose is to promote and maintain a high level of public trust in the appraisal practice. Licensing and educational bodies exist to train, regulate, and support appraisers and the appraisal profession in following USPAP. Organizations such as TDLR, TALCB, IAAO, and TAAO exist for this purpose and could not exist without USPAP. The Texas Property Code mandates that all appraisers and appraisal districts adhere to USPAP, as does the Texas Department of Licensing and Regulation, TDLR, and the Texas Appraisers Licensing and Certification Board, TALCB, and the International Association of Assessing Officers, IAAO, and the Texas Association of Assessing Officers, TAAO. In fact, the Texas Property Tax Code specifically identifies TDLR as the agency responsible for certifying property tax professionals in Texas and for providing training, curricula, and materials for appraisers and assessor collectors. With regard to appraisals and the appraisal districts, part of the Texas Property Tax Code, Chapter 23, Section 2301B, states that, quote, "The market value of property shall be determined by the application of generally accepted appraisal methods and techniques," and that, quote, "if the appraisal district determines the appraised value of a property using mass appraisal standards, the mass appraisal standards must comply with the Uniform Standards of Professional Appraisal Practice," end quote. The Texas Constitution, Article 8, contains a very specific language that, quote, "taxation shall be equal and uniform," end quote, as is also required in USPAP and the Texas Property Tax Code. The point here is that the law relies on and requires USPAP, and USPAP relies on the law. They are codependent. They are not independent. Violation of USPAP is a violation of law. Under no circumstance does an appraiser licensed in the state of Texas, nor does any appraisal district in Texas, have the option not to comply with USPAP and generally accepted appraisal practices. Many violations of USPAP by the Denton Central Appraisal District have been identified, all of which are violations of law. All are at the hands of DCAD, its employees, board of directors, and their enablers. Let's briefly discuss some of the violations in mass appraisal USPAP standards. They violated the records-keeping rule. From the deposition of Chuck Sailing, it is clear DCAD has a pattern and practice of destroying records and spreadsheets from their analysis. From well-documented personal experience, DCAD has destroyed subpoenaed evidence. DCAD has also destroyed recordings of ARB hearings. By not keeping proper records, you can easily see how this is a violation of the ethics rule. By falsifying income and expenses of income property and by not using legitimate comparisons on income property and residential property, DCAD and its employees have violated Rule 5-1 by not correctly employing recognized techniques to produce a credible mass appraisal. From this same falsifying of income and expenses, and by not using legitimate comparisons on either income property or residential property, flows a list of intertwined violations. For example, committing substantial errors of omission and commission, rendering mass appraisals in a careless and negligent manner, failing to consider location and economic characteristics, failing to determine the scope of work to produce credible results, failing to develop math models that lead to reasonable certainty, failing to employ recognized techniques for calibrating the mass appraisal models used. We will revisit this failure with regard to additional fraud of the subcategory shortly. Failing to reconcile the quality and quantity of data available. Failing to use appraisal testing procedures and techniques to ensure that standards of accuracy are maintained for mass appraisal. As a result of the violations we have discussed so far, DCAD's property values are not derived following the appropriate USPAP standards. The values are a product of manual override manipulation or dirty data that results in DCAD filing reports that are misleading, fraudulent, and criminal, all of which is a violation of Rule 6 of USPAP. We will discuss more of the criminal aspect shortly. Next, let us review violations of USPAP Standard Rules 1 and 2, which are rules for real property appraisal, development, and reporting. DCAD and their appraisers fail to employ USPAP methods to produce credible appraisals, commit substantial errors that significantly affect appraisals, fail to identify characteristics of property that are relevant, fail to use relevant information that is physically in their possession as it has been provided year after year, ignore comparable properties, fail to test proposed values against like-kind properties, lie to the ARB panels by presenting comparables that are not mathematically quantified as comparables, and mislead the real estate taxpayer about comparables that are not, in fact, comparables. The net result of this behavior and of these violations is intentional fraud by falsifying records and thus falsifying the initial notice of property values, continuing to falsify values in protest hearings, and further continuing to falsify records on certified tax rolls provided to the public, taxing entities, and state comptroller. What would you do if one day you received an appraisal notice with the value of $1.2 million when the prior year was $400,000? This may be an extreme example, but it has happened. Your taxes would go from roughly $8,000 to $24,000 on that 300% value increase. Now, file your protest, file your appeal or lawsuit, pay the taxes, and then after many delays, DCAD will negotiate a settlement outside the purview of the public and the courts using taxpayer funds. They falsify a value, extort funds, then settle, all of which is illegal under multiple state and federal laws. Just in case you think this can't happen, it did to my property in Flower Mound, and the evidence is on the mockingbirdproperties.com/DCAD website. The falsification of values occurred year after year, causing multiple lawsuits. You see, DCAD is literally making up the initial property values out of thin air, from which there is no possible justification in law or appraisal standards. When challenged by a taxpayer filing a protest, they attempt to justify their lie and cover up their fraudulent value with improper comparisons. DCAD presents comparisons that are in fact not comparisons, and the taxpayers can't respond on the spot fast enough because they don't understand or cannot believe what just happened to them. As for the ARB panels, their presence is often an illusion of an independent body, as the ARB is controlled by and paid by DCAD. It is abundantly clear that both criminal and civil prosecution is warranted for DCAD and those employees who have violated their licensing requirements. DCAD has violated the Texas Property Tax Code, Chapter 23, Appraisal Methods and Procedures, Section 23.012, for the income method of appraisal. Let's do a quick review of this method and the data that should be utilized in valuing a shopping center. This section of Property Tax Code states that DCAD, the appraisal body, shall use comparable income and expense data and the property's own historical data in valuing commercial property under the income approach after identifying the trends and averages of the property and its comparables. A comparison of like-kind income-producing property should include age, location, income by line item, expenses by line item, extraordinary situations, functional obsolescence, demographic profile, etc. By examining these inputs, one can run a standard deviation and/or linear regression looking for outliers in each of the line items. Removing the outliers from the list of potential comparables helps to further define what is a legitimate comparable, which will usually result in a 1/2 standard deviation bracket, which is reasonable. In light of how data is supposed to be evaluated and utilized under all appraisal standards and laws, DCAD does not, under any circumstance, get to pull an expense figure or an income figure out of thin air. In 2022, DCAD used an annual operating expense number of $24,910, or $2 a square foot, in preparing an income calculation worksheet. The income calculation worksheet is a tool used to do an income approach appraisal. In the case of Mavex Shops of Flower Mound, the prior year's operating expenses were $71,821. That's $5.76 per square foot, which is nearly 3 times higher than the figure DCAD made up. By inserting a lower expense figure, DCAD increased the net operating income. By increasing the net operating income and deploying a made-up cap rate, DCAD increased the appraised value in an arbitrary and capricious manner. The bottom line is DCAD is committing fraud. Now, let's dig a little deeper. DCAD has in its possession the operating statements for the Mavex Shops of Flower Mound property going back over 10 years. And in fact, they collect this information annually from commercial properties in the protest process, meaning they have other comparable properties data as well. So, they have the historical expenses and the trends that could and should be utilized, but they don't use them. Why then, if this information has been collected, is it not used in the appraisal process or on the income calculation worksheet? Because the actual data does not support the narrative of the predetermined value, which is a fraudulently inflated value. The appraisal district's expense figure was lowballed for the specific purpose of affecting the calculation of net operating income that is then used to derive the appraisal value. Again, lowering expenses increases the net operating income, and that increases the appraisal valuation. The figures they used are not comparable or appropriate and did not represent the trend or average of other similar properties. They manipulated the income calculation worksheet. Now, let's look at Exhibit L, and you will see how this manipulation takes place. We often refer to this exhibit as Exhibit L or Schedule L. It was presented on Tab L in the Mavex Shops of Flower Mound's 2022 Protest Hearing Presentation booklet. As mentioned before, DCAD presented an income calculation worksheet for the 2022 hearing, placing value on Mavex Shops of Flower Mound at approximately $2.8 million, or $2,724,929. The 2022 Notice of Appraisal was also issued at this exact value. Surprisingly, this was the first time DCAD presented an income calculation worksheet that matched the Notice of Appraised value. Usually, the income calculation worksheet presented at the hearing has a higher value than the value put on the notice. Again, always questions with DCAD's values, and this is further indication of manual override of the income calculation worksheet to a predetermined value. We recreated their worksheet to do a comparison where the actual data was inserted and a more appropriate cap rate was applied. On this exhibit, each time you move one column to the left, away from DCAD's original worksheet, we replaced their figures with actual figures that corrected DCAD's computation. The effect on the property valuation by inserting actual data is huge. Here, the far right column represents the data and figures that DCAD inserted into their income calculation worksheet for the $2.8 million valuation. The first adjustment to review is with the property operating expenses. In the column just to the left of DCAD's original worksheet, we replaced and corrected the property operating expenses with actual figures. We left the property tax expenses figure alone for now. This update lowers the net operating income from $198,417 to $77,910. This is a $120,000 reduction to the net operating income, and this lowers the property value calculation by approximately $1,700,000, bringing the $2.7 million valuation down to $1,003,404. The next column to the left, or next adjustment, corrects the property tax expenses for tax on a $1.2 million value. With this correction, the net operating income is calculated at $109,728. A more appropriate cap rate is then applied, and the valuation proofs itself up as the $1,181,319, or approximately $1.2 million, is the same value used to calculate the property tax expense. Finally, the first column on the left, the furthest from the original DCAD worksheet column, uses actual income, actual expenses, and actual capital repairs. It assumes the property will pay taxes on a value of $1 million and applies the most appropriate cap rate, a 10 cap. Note, this is a cap rate we found in our DCAD cap rate survey. And again, with these corrections, using actual data, this valuation workup also proofed itself, as the indicated value of $978,279, or approximately $1 million, resulted, and the tax expense deducted was based on the $1 million value. Note, this is the most appropriate column calculation. Now, to be crystal clear on what this has demonstrated, DCAD has fraudulently and intentionally, with zero legitimate comparisons, and with years of historical income and expense information in its possession, created a fake income and expense statement. DCAD reduced the operating expenses from $71,821 to $24,910 to manipulate the worksheet results. There is zero mathematical, legal, or appraisal standards that allow the arbitrary and capricious creation of the initial notice of value and creating fake income statements. In fact, if I walked into a bank and presented that bank with the exact same fake income expense statement created by DCAD and then drew down on a loan for an extra $1.7 million based on that fraudulent valuation, I would be put in jail, and justifiably so. Let's review another example of a violation of the Property Tax Code. Under Chapter 23, Section 23.01e, Section 4 Appraisal Methods and Procedures, it states, quote, "If property value was reduced by Subtitle F, then, in the next tax year in which the property is appraised, the chief appraiser may not increase the appraisal value of the property unless the increase by the chief appraiser is reasonably supported by clear and convincing evidence when all of the reliable and probative evidence in the record is considered as a whole." As you can see in the graphic, DCAD has violated this law year after year with the Mavex Shops of Flower Mound property. It does not matter whether you are a homeowner taxpayer or an income property taxpayer. When the initial notice of property values are fraudulent, the law has clearly been broken, and the ramifications of that are extremely serious. If the property value on your home goes up 300% in 1 year, can you afford to pay the taxes? If the income property has less income, say due to COVID, and its property value goes up by 300%, where's that money going to come from to pay the taxes? Again, the ramifications of fraud run deep. Let's look at an analysis we performed on a sample of just 140 commercial shopping center properties to review their values before and after protest and as compared to the prior year. The sample group represented 6 class codes of shopping centers in Denton County in 2020. These 6 class codes were selected because they included comparable class codes to the Mavex Shops of Flower Mound property. The analysis was done over several years, with the most recent update completed in November 2022. Let's look at a few main points of the analysis. In 2020, the initial appraisal values were increased by 77.05%, above the prior year. 93% of the group had their values reduced after protesting, appealing, and legal. In 2022, the initial appraisal notice values were 80.86% higher than the prior year. Then, much like before, 92% of this group ended up with their values being reduced. With a large percentage of this 140 protesting in each of the 3 years reviewed, there are many examples within this group that have also experienced a violation of the Texas Property Tax Code 23.01e. Under this section of the law, it states that the chief appraiser must have clear and convincing evidence to increase value of a property for the current year if the prior year had been reduced by the protest and/or appeal process. This analysis demonstrates that this violation in law is occurring throughout Denton County and on a mass scale. Continuing on, the comparison of values before and after the protest also identified that not only were there a large number of values reduced, but that reductions were a large percentage of value below the initial value. Average reduction in value was around 32% for 2020 and 2022. There is no appraisal law or method which can create such gyrations of annual increases, followed by subsequent substantial decreases, but for falsifying the initial property values. To be clear, in the past 6 years, Mavex Shops of Flower Mound has had an initial appraisal notice issued with their value increasing between 160 and 320% from the prior year. Under either scenario, in mass or individually, this is a violation of multiple laws. The taxpayers should ask, show me the legitimate math and appraisal law, along with the legitimate comparisons that allows for a mass increase of 77.05% or an individual increase of 300%. There is no such thing, and this is the proof that DCAD is corrupt and in fact extorting the taxpayers by using the process as a negotiating, racketeering vehicle. Look at all the money, time, and effort spent by the taxpayers fighting fraudulent initial property values, which are completely, irrefutably made up. Look at all the taxpayer money being wasted by DCAD because they create fraudulent values and then pay attorneys to help negotiate away over 500 lawsuits per year. DCAD violated Texas Property Tax Code, Chapter 23, Appraisal Methods and Procedures, Section 23.01b. In the second clause of Chapter 23, there are 4 procedural directives. Market value of property shall be determined by application of generally accepted appraisal methods and techniques. This is USPAP Professional Standards 1 and 2. If appraisal district determines appraised value of property using mass appraisal standards, the mass appraisal standards must comply with USPAP, USPAP Professional Standards 1 and 2, as well as Standards 5 and 6. Same or similar appraisal methods and techniques shall be used in appraising the same or similar kinds of property. However, each property shall be appraised based on the individual characteristics that affect the property's market value, and all available evidence that is specific to the value of the property shall be taken into account in determining the property's market value. For Mavex Shops of Flower Mound, DCAD has also violated this basic and general rule, along with others, as they ignored actual property performance data, income, expenses, lease occupancy, location, etc., that was provided year after year when applying it to the income calculation worksheets. This was very clearly evident on the 2022 income calculation worksheet DCAD prepared. DCAD violated the Texas Property Tax Code, Chapter 23, Appraisal Methods and Procedures, Section 23.01f and Section 23.013. DCAD violates Section 23.01f and Section 23.013a by not using true comparable properties in analysis to render value based on how a property compares with local, like-kind properties, equitable value, uniform and equal, or how it compares with like-kind properties' sales value. Mavex Shops of Flower Mound can demonstrate that improper comparison analysis was reflected on notice of appraisals issued. Please refer to these reports provided on the website. Standard deviation analysis of Mavex Shops of Flower Mound with its comparables, history of Mavex Shops of Flower Mound comparisons from 2011 to 2022, Tab A, 2022 hearing booklet. Note: this 2022 update includes analysis demonstrating that from 2011 to 2019, these 11 are the comparisons, as Mavex Shops of Flower Mound's value per square foot on average was within 7% of the group's median value per square foot. After the protest and appeal process is complete, Mavex Shops of Flower Mound is valued within the range of its true comparisons. Justin Road Area Comparables, 2016 to 2022. Mavex Shops of Flower Mound Value Comparison from 2019, 20, 21 on 4 separate dates for each tax year. 2020 value charts of Mavex Shops of Flower Mound with comparisons on 4 survey dates. Under the Texas Property Code, Chapter 42, Section 42.26, DCAD violated the law by issuing values that are not within 10% of the median value of a group of comparable properties. In Section 42.26, it states, A, the district court shall grant relief on the ground that a property is appraised unequally if 1. The appraisal ratio of the property exceeds by at least 10% the median level of appraisal of a reasonable and representative sample of other properties in the appraisal district. 2. The appraisal ratio of the property exceeds by at least 10% the median level of appraisal of a sample of properties in the appraisal district consisting of a reasonable number of other properties similarly situated to or of the same general kind or character as the property subject to the appeal. Or 3. The appraised value of the property exceeds the median appraised value of a reasonable number of comparable properties appropriately adjusted. It goes on to state, if a property owner is entitled to relief under subsection A1, the court shall order the property's appraised value changed to the value as calculated on the basis of the median level of appraisal according to subsection A1. What is so interesting about uniform and equal is that it is also the law under the Texas Constitution, Article 8, and as such, the judge must enforce it. This begs the question, why would DCAD fraudulently create the initial notice of value when DCAD has the evidence of value in their files and knowing full well that a judge must enforce the law under the Texas Constitution? The answer is extortion. Let's look at bias and/or extortion. If the shoe was on the other foot, how could the actions of DCAD and its employees not be bias? Assuming Mr. Posey, an appraiser working for DCAD, lives in a $400,000 home. He would certainly not appraise his home for $1.2 million, now would he? Appraisers are entitled to their opinion based on the confines of law and USPAP, but what they are not entitled to do is invent their own data or manipulate the data. Data is what it is. No appraiser in law has the right to make up data, pick and choose what they want, and then apply it to meet their intended outcome. This is illegal and is in fact the definition of extortion. Pay me or I'll take the property, and thus a taking. Pay me and then sue me to prove me wrong. It's a triple net property. Make the tenants pay. Under any of these DCAD premises, DCAD and its employees have broken the law. Linear regression, standard deviation, direct comparison, comparison grids, the entire appraisal process, the requirements under TDLR, TAAO, TALCB, Texas Property Code, Texas Constitution, and USPAP would have no meaning if DCAD and its employees have the right to make up data. There is not one single paragraph in law, USPAP, Mass Appraisal Standards, TAAO, or anywhere that allows any appraiser to make up data. Just the opposite. The tentacles of fraud from DCAD and its employees and co-conspirators and the ramifications from falsifying the initial property values run deep, and all because DCAD has intentionally invalidated and made meaningless USPAP, Texas Constitution, Texas Property Code, IAAO, TAAO, TALCB. They are even making a mockery of the Texas Comptroller, who is responsible for performing ratio studies on appraisal districts. The state comptroller's ratio studies are flawed given that the data created by DCAD is dirty, which means that their published ratio studies are proof of the statement in data science, garbage in and garbage out. All these violations in, of, and by multiple governing bodies cannot exist but for the intent to defraud. Violations of USPAP professional appraisal practice rules were made by individual appraisers and by DCAD itself. Not only is DCAD liable for the violations of USPAP and law, but so are the individuals who have perpetrated the violations and thus the fraud. The individuals, employees, violated the record-keeping rule. They did not perform their assignments with impartiality, objectivity, and independence. They did not act in good faith by not employing proper research, methods, and techniques that resulted in falsifying the value on the notices of appraisal. It is a violation of ethics not to promote and preserve the public trust, and therefore the individuals are jointly and severally liable as they have violated their licensing requirements, wherein the net result is fraud on a mass scale. Next, we want to talk about the violations under TDLR. TDLR is a licensing and regulation agency empowered by the Texas Property Tax Code in Code Section 5.04 to certify tax professionals and provide training and education to appraisers and assessor collectors, which includes the Uniform Standards of Professional Appraisal Practice, USPAP. DCAD and its employees have failed many, if not all, requirements under the Texas Department of Licensing and Regulation, aka TDLR. On the Mockingbird Properties /DCAD website, there are over 50 documents that back up the violation summary document titled DCAD Violations in Appraisal Licensing and Property Tax Code. This violations log provides 34 pages of direct reference to all the exhibits and all the violations of USPAP, Texas Property Code, Texas Constitution, IAAO, TAAO, TDLR, and TALCB, all of which are a direct result of the fraudulent behavior and actions of DCAD and its employees. We have also outlined the potential damages model for the last 3 years as a result of the fraud. These damages range between $822 million and $1 billion. These are dollars charged and collected above any justification in law and USPAP, and these damages do not count the damages at the municipal entities and school districts, including their bondholders. With regard to DCAD, its employees, and the board of directors at DCAD, we can summarize what they have done. Ignored data collected, ignored prior years' protest, appeal, value reductions, inserted improper data on the income calculation worksheets, failed to identify or use actual, proper, comparable properties, issued improper notices of appraisal, created high volume of protests, over 107,000 in 2022, created a high volume of lawsuits, nearly 500 lawsuits each year since 2018, created unnecessary protests and appeals, resulting in large reductions, with high percentage values, 30, 50, 70%, etc. See our analysis on a sample of 140 shopping centers. Every one of these items is a violation of USPAP and law. If DCAD was adhering to USPAP and not fraudulently creating the initial notice of value, none of the above would have occurred. The end result of their actions is that the appraisal process ends up being a sham or a scam. Speaking of a scam, DCAD has employed subterfuge in the creation of class codes. Class codes allegedly further define the elements of a property such as a stone wall versus brick wall, shingle roof versus clay tile roof, excellent condition versus poor condition. And for commercial property, the codes are supposed to be used to not only describe quality and type of construction, but also to identify the purpose of the building, quality of location, and the actual income. With the 2022 appraisal year, DCAD made major changes to the class codes for shopping center properties. They went from using just 6 class codes to describe our sample of 140 shopping center properties to using 28 class codes. In this sample, we found cases where properties were recategorized and given a new code that dropped them from a Class A2 to Class A5, and they still had their values increased by 29 to 98% on the 2022 appraisal notice. There are several problems with their coding. One, many of the properties we looked at, being residential or commercial, had an improper class code assignment and/or coding that was different than the same like-kind properties in the same geographic vicinity. 2. Uniformity of the coding application is non-existent. 3. Most people don't even know the class codes exist and how these codes are being used against them. 4. Who verifies the proper application of the class codes to the property and into the database? The only conclusion is subterfuge for the purpose of stealing money. Just another scam perpetrated by DCAD. Let's go back to the Texas Department of Licensing and Regulation and discussion of scams. We now have questions about this government agency. With TDLR cited in the Property Tax Code as providing education, licensing and regulation of tax appraiser professionals, we filed a complaint with them regarding DCAD's appraisal practices. The complaint was filed in November 2022. In February 2023, we received correspondence from a senior investigator, and despite all the information provided when the complaint was filed, his response was that he needed to inform DCAD of the complaint and get feedback from DCAD before he would know which steps to take next in the case. He admitted to not reviewing everything we submitted, which was 4 documents, and he suggested we file complaints with the state comptroller and/or the Office of the Attorney General. Funny, or rather not so funny, it was state officials who we contacted first, and they suggested that we seek local and other remedies. This TDLR representative also went further to state that while Section 94.100 exists in TDLR's rules and regulations, that TDLR may not have actual authority to take action on these violations. It appears TDLR will not provide any real help in this matter. They have pointed the finger elsewhere and confessed to not having authority in their own regulations that are part of the Texas Administrative Code. So, what is TDLR's real purpose? Do they have one? Let's review the Texas Appraiser Licensing and Certification Board, aka TALCB, the licensing division responsible for licensing appraisers. Per their website, the Texas Legislature established the Texas Appraiser Licensing and Certification Board to safeguard consumers in matters of real property appraisal services. TALCB provides education and licensing services, as well as regulation and enforcement of state and federal laws and requirements that govern real property appraisals. Chapter 153 contains the rules relating to provisions of the Texas Appraiser Licensing and Certification Act. Under Section 153.8, DCAD and its employees can't get past the very first sentence, which states, license holders are bound by the USPAP edition in effect at the time of the appraisal. As you can see in the graphic, they fail to adhere to this very simple requirement. Section 153.15 goes on to detail additional licensing requirements, all of which DCAD and its employees involved in the fraud have failed. As we discussed earlier, they have failed to follow USPAP Professional Standards 1 and 2, Standards 5 and 6 in mass appraisals. TALCB requires experience and adherence to USPAP. We filed a formal complaint with TALCB, naming the Denton Central Appraisal District, the chief appraiser, former and present, along with other appraisal staff members. The response by TALCB was that they did not have jurisdiction over an appraisal district or property tax professionals, and they suggested we take our complaint to TDLR, which, as we mentioned earlier, we already have. It should be noted that a TALCB licensed appraiser prepared an appraisal on behalf of DCAD, and the report issued contains similar violations of appraisal law that led to the same improper valuation made by DCAD. Further, we tried to get help with this property tax appraisal matter by contacting several state representatives and officials. They told us to seek remedy at the district level. We have been discussing these issues over many tax appraisal cycles since 2016. I spoke directly to the board of directors, the public, and the press in a Denton Central Appraisal District meeting, and I presented them with a binder of information regarding the appraisal violations. None of these interactions with the appraisal district or the board has resulted in an acknowledgement of the appraisal problems nor a change in their appraisal practices. Next, we filed a complaint with the Texas Department of Licensing and Regulation, and their response included a statement saying they may not have the authority to take action, which leads us to TALCB, the more recent complaint that was just filed. And as we just discussed, they said they don't have jurisdiction. So, how do we get resolution? How do we get the appraisal process corrected? How do we stop DCAD from violating the appraisal law and the rules and guidelines that are mandated by the law itself, the Texas Property Tax Code, and Texas Constitution? We have followed up with TALCB with this question, telling them about our interaction with TDLR prior to contacting them and asking them for suggestions and guidance in this manner. With none of the regulating agencies, including the Property Tax Assistance Division of the State Comptroller's Office, providing assistance and holding DCAD, the Chief Appraiser, and their appraisal staff accountable to appraisal standards, USPAP, and legal standards, it does appear that the only course of action remaining is by filing suit at both the state and/or federal levels. Falsifying income and expense statements, falsifying government reports, creating comparisons that are not comparisons for purpose of creating higher values are criminal actions. Given what the evidence has shown, if TALCB or TDLR or the State Comptroller were legitimate enforcement organizations, then step 1 would be to pull and bar licenses of those who have violated their licensing requirement as well as the law. Step 2 would be to put proper additional education in place that includes linear regression, standard deviation, how not to commit fraud, and how to adhere to USPAP. Step 3 would be to create a series of educational hurdles to ensure that a person working on residential houses is not allowed to value income properties or industrial properties until such time as they have at least verification of 2 or more years of experience in that particular area under the supervision of a proven professional. If TALCB, TDLR, and the State Comptroller fail to pull the licenses of those defrauding the taxpayers, that would clearly show lack of credibility on their part, and therefore their very existence should be called into question. Are each of them just another entity that provides lack of training, churning out compromised individuals for the sole purpose of having their hand out for fees? We have deposition testimony from Chuck Sailing stating that an RPA with as little as 50 hours of training can determine property value. This statement is astonishing and explains exactly how creating fraudulent initial property values occurs at the demand of the administration of DCAD. If you want a job that pays and provides early retirement, do as you're told. We need higher valuations. What we have uncovered is fraud on a mass scale and what appears to be a cover-up by multiple government entities, which in the last 3 years has cost taxpayers between $822 million and $1 billion conservatively. There is plenty of blame to go around, and from what I have seen, TALCB, TDLR, and the State Comptroller need to take a good look in the mirror and take action. If not, getting a license from TALCB or TDLR is nothing more than paying for an expensive box of Cracker Jacks and getting a prize. One hopes that one of these regulating agencies, TALCB, TDLR, or the State Comptroller, will be honorable and stand up for this situation. But if those administering education, and in this case of the Comptroller overseeing DCAD, don't understand USPAP, the Texas Property Code, and the Texas Constitution, and just pay lip service to USPAP, then they may also be an enabler or co-conspirator. Time will tell. It is frustrating that we're trying to engage the RPA, Chief Appraiser, and DCAD's attorney with the evidence in an income and expense statement, true comparisons, linear regression, and standard deviation. Their eyeballs glaze over. It is clear that they A, have been caught, B, are clueless of their responsibilities, C, don't understand math, and as a result, D, are committing fraud. There is no defense for their ignorance, as it is their job and their responsibility. Anything less is fraud on a mass scale. To this point, we'll go one step further and point out that there is not one single person in DCAD who can provide the necessary checks and balances to make sure the math is tied to the law. The open letter posted at mockingbirdproperties.com/DCAD discusses this topic further. And what about the government agencies like TDLR and TALCB that so far have not acted on complaints filed and the violations we have identified and documented? When those entities are responsible for education, licensing, regulating, and removing licensing for violations, and the entity, TDLR, chooses to do nothing, regardless of the overwhelming evidence, then for what legitimate purpose should that entity exist? Could that entity be part of the scam? Telling unsuspecting individuals that they're getting an education, taking their money, putting them in a position to be indoctrinated into the scam, and then stealing the public's money shows the level of nefarious actions by a contrived system with no checks and balances. We have gone out of our way to give these entities the benefit of the doubt. However, the way we look at it, as these entities have been told and shown multiple times that the law is being broken, and so far they have chosen to do nothing about it, then they are complicit, and as such, perhaps the entire operation of TDLR should be shut down for failure to enforce what they profess in writing is their rules and regulations. At the moment, TDLR appears to be an enabler of DCAD. Why? DCAD is a cash cow that steals taxpayer money by committing fraud in the initial notice of value, then transfers the overcharged receipts to local entities with a pass-the-buck, turn-a-blind eye, no enforcement policy by the regulating authorities such as TDLR and TALCB, and all to keep the cash cow mooing. Without enforcement, there is no reason for these entities to exist, as they are also taking taxpayer money. So, the next question is, how can your state, local, and municipal politicians make a change when they are as clueless on the facts and math as DCAD and the district's employees? Leave aside the probable intentional cluelessness and realize the politicians in Austin prance around stating we are lowering property taxes, when in reality, this is an empty, meaningless statement because property values, by virtue of the fraud, are going up. If the state places limits and rules for tax rates, exemption types, or exemption amounts, etc., the appraisal district's response will simply be to increase the values further, which again is outside of the appraisal standards, which is a violation of the law. The left hand giveth and the right hand taketh away, leaving the victims in their wake. There were several articles in the Cross Timbers Gazette in 2022 that were basically congratulating and or patting the backs of several taxing entities in the Denton Central Appraisal District, including Denton ISD, Northwest ISD, Louisville ISD, Argyle ISD, Town of Flower Mound, Highland Village, Lantana, and Denton County, because they did not increase their tax rate in 2022 or because they reduced their tax rate for 2022. With property values being increased so dramatically over the last few years, with no actual basis for doing so in appraisal law, the cities, schools, and county have more funds than they should have. Keeping the rate static or reducing the tax rate is just a gesture, and the problem of fraudulent values remains. When you explain and show the facts as outlined in this video, there is simply no defense for DCAD or the politicians. Facts and math matter, and in this case, it irrefutably proves fraud. Politicians routinely talk about things they know nothing about, and this video will give them the knowledge and facts, so the only question is, what are they going to do about it? One would hope that they're not going to be complicit in theft of taxpayers' money. I want to take a moment here towards the end to discuss the co-conspirators of DCAD, which is the Board of Directors. DCAD causes hundreds of lawsuits and tens of thousands of protests each year. There were over 500 lawsuits filed in the last 12 months and over 107,000 protests filed for 2022. If they were adhering to their legal requirements, the number of protests and lawsuits would easily drop by 80%. DCAD causes the problems, hires attorneys to fix the problems using taxpayers' money, then holds their hand out for more taxpayers' money only to create more problems by hiring more employees, none of which have the proper training, yet do the bidding of the leadership, which is clearly corrupt. All because they intentionally refuse to follow the law. As you have seen throughout this video, their actions are not by mistake. The board also has been shown and told multiple times about the problems and refuses to take corrective action of any kind. Therefore, by law, as seen in the graphic, the board is as corrupt as DCAD and also in violation of the law and their signed oath. Each board member and chief appraiser signed an oath to protect and abide by the laws of the state of Texas and the United States. With the violations in law that have occurred throughout the DCAD appraisal process and practice, they have clearly broken their oath, which is grounds for immediate termination followed by prosecution. Above and beyond the oath of office taken, any elected or appointed official or attorney refusing to honor an acceptance of their oath is simply impersonating a public official, violating the Texas Penal Code 37.11 law regarding impersonating a public servant, which is a third-degree felony. So by defaulting in their duties and obligations of their office, they have broken the law. And under Title 42 of the United States Code, Section 1986, it provides that every person who has knowledge that a wrongful act is about to be committed and having the power to prevent the commission of such wrong, neglects or refuses to do so, is liable to the party injured for all damages caused by the wrongful act. Defendant in a Section 1986 action need not have participated in the conspiracy or the commission of the act. Just having knowledge of it implies guilt. Any number of persons guilty of wrongful neglect or refusal may be joined as defendants in a 1986 action. It is also imperative to understand that the appraisal district board's first and primary duty is to hire or appoint a chief appraiser, meaning the chief appraiser is their responsibility. And while the chief appraiser is the chief administrative officer of the Central Appraisal District, they serve at the pleasure of the appraisal district's board of directors. With regard to the chief appraiser and the appraisal district staff, in addition to any oath of office or oath of a professional taken, the appraisal district representatives in ARB protest hearings take an oath to tell the truth before presenting evidence to support appraisal value, as does the taxpayer and/or their representative. The chief appraiser certifies the tax roll and property values under oath to the public, also under oath to the tax collector assessor, to the cities, schools, and county taxing entities, to the state comptroller, and to the board with which he or she reports. If the district's appraisal work has not been completed in compliance with the law, they are also committing perjury in each of these settings. There are several sections of law that pertain to perjury. Perjury in a dictionary is defined as the act or crime of knowingly making a false statement about a material matter while under oath or bound by an affirmation or other officially prescribed declaration. Title 18 is the main criminal code of the U.S. federal government. In Section 1621 of this code, perjury is summarized as anyone in any case in which the United States authorizes an oath to be administered, that he, after having taken oath, will testify, declare, depose, or certify truly, or that any written testimony, declaration, deposition, or certificate made is true. Any testimony, declaration, deposition, or certification to the contrary that is not true is perjury, making that person guilty of perjury. It is clear, with all that has been discussed and demonstrated, the board is a co-conspirator with the appraisal district in a conspiracy to defraud the public, and as such should be removed and then prosecuted. This oath exists for a very specific reason. Given the evidence we are providing, an action not taken by the rightful authority would make that authority complicit and aiding and abetting in a criminal conspiracy to defraud. Again, USPAP, TDLR, Texas Constitution all exist for a reason, as does the oath. Why does DCAD and its enablers refuse to adhere to the oath and the laws under which they exist? The only answer is extortion. In summary, there is no way around the evidence against DCAD. It is DCAD's forms, DCAD's numbers, DCAD's dirty data, and DCAD's fraud. Add into this equation DCAD's annual reports, which do not prove and which do not have notes. It is irrefutable that this organization is systemically corrupt to the bone. DCAD paints a picture of legitimacy, going as far as to use TAAO certifications of DCAD in their presentations, yet the evidence gained from DCAD's own numbers, as shown in this video and available on the Mockingbird website, is the exact opposite. This video is a short view of thousands of hours of research by my company. On the website is a 10-page open letter to taxpayers, which goes into further detail than this video, without having to review all the documents on the website. The open letter outlines solutions which can be enforced through the state legislature and quickly. The intent of this video is to provide full exposure of DCAD, its employees, board of directors, and any co-conspirator in the chain. I thought you would find it interesting that so much money is being stolen and the public does not know how. They just know there's a problem. We were able to quantify the issues and tie all those issues back to the law, and now it is time to take what we know and ask the government officials, including the state legislature, FBI, Texas Rangers, SEC, and DA to get involved by bringing criminal and civil charges, create the enforcement mechanisms, and also ask the property owners to do their job by getting involved and notify the authorities and other government officials about DCAD's effect on their property values in a concerted effort to put a stop to this nonsense. The more citizens and press helping to inform the authorities, the better. As I stated in the beginning of this presentation, understanding the fraud being committed by DCAD and taking action may save you thousands, if not tens of thousands of dollars. I suspect that many other appraisal districts in Texas suffer from the same fraud, as once you understand what is happening, it is easy to replicate because there is no enforcement. We are in tough times, and they are about to get much tougher. The arrogance and criminality of those who steal can only be stopped by the community in which the crime has occurred and continues to occur. We invest in real estate and businesses in the community, and we are doing everything we can to bring this issue into the sunlight. Sunlight is a good disinfectant. If you like the video, please send an email to me, mitch@mockingbirdprop.com, and I'll add you to my private email list to keep you informed on this topic. If you have any questions, please contact me at mitch@mockingbirdprop.com. Please forward the link of this email to those who can use your help: Real Estate Taxpayers of Texas, friends, family, business associates, local, state, and federal representatives. Thank you.